Okay, Ms. Smith, you may proceed.
When I call your name, our bailiff will tell you where you need to sit. Christina Brandt. Joshua Yarbrough.
He can use one of those spots right there. He can use one of those spots right there.
Sharon Diaz. Peter Anglin.
They got some
Nancy
there.
Fontenot. Kelsey Crippen. Bridget Moore.
She's gonna sit right there. Watch that tag. Defense, you have any objections to the panel?
No.
State?
No objection, Your Honor.
Okay. Now, ladies and gentlemen of the jury, I must administer to you the oath, and I need each and every one of you to raise your right hand. And once I finish making my statement, you can say, "I do." Do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Damaco Grace Crippen, you will a true verdict render according to the law and the evidence, so help you God? You may put your hand down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I am the sole judge of the law. You are the sole judges of the credibility of witnesses and the way to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I am the sole judge of the law. I can't be with you in the jury room when you deliberate the fact, therefore you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. You will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The bailiffs have given to you name tags identifying you as a juror. Please pin it on and wear it at all times. Now, ladies and gentlemen, those of you who was on the panel and was not selected to sit on this jury, on behalf of the citizens of Jefferson County, and behalf of the staff here in County Court at Law Number 2, I'd like to thank you for taking time out from your busy schedules to be here this afternoon. It's because of people like you, we can move our docket. Without individuals like you, we would have a long list of backlog of cases. But because of individuals like you who took time out from your busy schedules, we are able to move our docket. So on behalf, again, of the citizens of Jefferson County and behalf of the staff here in County Court at Law Number 2, I'd like to thank you. Ordinarily, I would give you a handshake, but because of our COVID pandemic, I'm going to give everyone an air handshake. And so again, thank you for being here. You're now in the hands of our bailiff. Now, if you need an excuse, you can go over to the district clerk's office. And if they are closed, I think we have some paperwork here that we can give you if they cannot provide it to you. So at this time, ladies and gentlemen, thank you for being here, and you're now in the hands of our bailiff. So at this time, State, will you present the information?
Just a second, Your Honor, I'm having a computer issue.
Okay.
In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Diamond Cole Grace Cribben, hereinafter styled the defendant, heretofore, on or about May 18th, 2017, did then and there operate a motor vehicle in a public place in Jefferson County, Texas, while said defendant was intoxicated, against the peace and dignity of the state of Texas.
Okay. Okay, now, Ms. Crippen, to the information as read, how do you plead? Guilty, not guilty, no contest? Okay, you may be seated. State, at this time, will you be presenting an opening statement?
Yes, Your Honor.
You may go forward.
Your Honor,
Yes.
I think I have an issue that I think we should address outside the presence of the jury.
Okay. Ladies and gentlemen of the jury, please follow the bailiff into the hallway. I'm gonna put this. I'm gonna put the mic on mute because if the juror see this on YouTube, they may hear what you don't want them to hear. Okay, so I'll just put this on mute. State, you have any objections?
No objection, Your Honor.
Defense?
No objections, but I think
Okay, y'all may be seated. We're back on the record in cause number 315529. The case is styled the state of Texas versus Damaco Grace Crippen. Let the record reflect that Ms. Crippen is present in court with her attorney, Mr. Jared Gilthorpe. The state is present with its assistant district attorneys, Attorney Daniel Boyd and Attorney Julie Maxey. Let the record also reflect that the jury is now present in the courtroom. Ladies and gentlemen of the jury, the hour is getting late. We're going to, at this time, we're gonna be in recess, and we will ask that you come back on tomorrow, and we need to be here for 2 o'clock. And the reason why we saying 2 o'clock is because, one, we have a docket in the morning that starts at 9 o'clock, and that may last to 11 or 12. And then we will have a hearing in this case that's going to start at about 1 o'clock. That's going to start at 1 o'clock. And so depending on what happened with the hearing, then we will expect you to, well, we'll be expected to start back at 2 o'clock. Okay? So at this time, ladies and gentlemen of the jury, you're free to go for this evening. Please follow the bailiff, and you have a blessed day. You keep your tags with you. We're being recessed.